Chairman, members of the committee, sponsor Rob. My name is Kirk Presley. I'm an attorney in Kansas City. I've practiced for 30 years. I'm a founding partner in Presley. A significant portion of my practice is devoted to representing insureds, businesses, individuals, policyholders who've been denied coverage. I'm involved in a significant number of insurance coverage matters at any given time. I've been so engaged for 30 years. In fact, I was an associate with the Faust law firm when they did Whitehead versus Lakeside Hospital. And I think it's important to note that under the existing law here in the state of Missouri, insurance carriers have three options. They can accept the claim as being covered for defense and indemnity, in which case the policyholder receives the full benefit for his premium dollar. It can reject or can agree to defend under a reservation of rights to deny coverage at a later date, but allow retained counsel that the insurance company retains to enter their appearance in the underlying claim on behalf of the policyholder and to control the defense. The third option is to deny the claim in its entirety and to refuse to defend at all, and that's the worst case scenario for any policyholder, because now he has to incur the expense for hiring his personal counsel to defend the claim. And many occasions, the duty to defend is almost as important, if not more so, than the duty to indemnify, because of the significant amount of legal fees that can be incurred in the defense, particularly of a significant claim. And so I wanted to address a couple of things that were brought up so far in testimony. One is, the sponsor referred to the expedited nature of this bill. And in reading it, I'm having difficulty finding out what the expedited process would be. As the law currently stands, when a claim is made, that claim, if the insurer rejects the defense and rejects providing counsel, the insurer can reach an agreement with the claimant to reduce that claim to judgment. That amount of that judgment has to be reasonable. The Supreme Court has said that for any judgment to be enforced by agreement with an insurance company, that insurance carrier has a right to a reasonableness hearing in any subsequent litigation on the coverage issue. And that case is Gulf Insurance versus Noble Broadcasting. So there are protections in place. And so while these judgments may be large, they are reasonable judgments in relation to the injury that's sustained. They may be well in excess of the policy limit, but that is a function of the nature of the damages sustained by the claimant, not as a result of any conduct or collusiveness that's alleged by the insurance industry in these agreements. Because no trial judge is going to approve something that isn't fair and reasonable, and that's required when most settlements are entered into. Further, any judgment that has to be fair and reasonable. And if not, the carrier can relitigate that in any subsequent hearing on the coverage under Gulf Insurance versus. So the expedited route is under existing law. The parties agree, they do an expedited trial before a court, it enters a judgment, then a petition for an equitable garnishment is filed, which is in essence a declaratory judgment. And the insurer gets to relitigate all the issues that relate to coverage. That's clear under existing law. And they get to provide any defenses to coverage, like the insured misrepresented its application, or that they weren't straight with us on the facts about how the claim arose. All of those defenses are preserved in the subsequent equitable garnishment. And so I can give you a real life example. I represented a small doctor group. The doctor was sued by a former partner. Some of those claims were definitely not covered, and we recognize that. One of the claims we contended was covered. We tendered the claim to Travelers. They denied. They refused to provide a defense. They refused to provide indemnity. And so the case got tried to a jury. And on the claim that we contended was covered, the jury brought in a verdict for $300,000. We subsequently entered into an agreement and said, okay, we're going to take that $300,000, and if in fact there's coverage, we will pay you the money from Travelers for that judgment. And in exchange, you're not going to come and garnish our billings to the insurance company for the care we render to our gastroenterology patients. And we lost that case. Travelers was correct. They were correct in denying coverage. And as a result, my clients were protected because they didn't lose any of their personal assets. The claimant, unfortunately, was not fully made whole because there was no coverage for that amount, but that's a risk he took. And he understood the risks, and that's the arm's length negotiation between adverse parties that reaches these. So there's nothing collusive about agreements simply because there's a mutual interest. I hope that helps. This is a somewhat esoteric, complex area of the law. I would refer the committee to the American Bar Organization. They have an excellent article called Reservations, Required or Not. And if you're so inclined, that can really help flesh out where Missouri falls.
I think what the chairman said, we're pretty aware of this kind of law technicalities to it, so we'll work good. I need to move along,
Yes,
so
sir.
I'm talking about, does anybody have any questions of the respondent or the witness? Saying none, thank you very much.
Thank you, Senator.
Yep. How many other people are here to testify in opposition on this bill? Any support? Is it just?
Just me too.
Okay, but if you're just going to say I'm in favor, let's do that real quick. Then we got one other gentleman to testify, but we're going to have to make that opposition quick.
Mr. Chairman, members of the committee, Ray Party President, Associated Industries in Missouri, you heard earlier that we were on record in support of this. Just wanted to be here in case of any questions.
Great.
Brian Bernskater here on behalf of the Missouri Organization of Defense Lawyers, going on record in support.
Thank you. We have one, last testimony, and this is opposition.
Right.
Okay. We're going to probably get about 2 or 3 minutes. That's going to be